This session is really about drafting written submissions. In other jurisdictions, they are called written arguments, but that's a small detail. It doesn't make a difference. So the purpose is to enhance participants' skills in drafting compelling, believable written arguments. So we hope that by the end of this session, participants and students and members will be in a position to effectively argue privacy-related issues in written form in a compelling manner. So I'll take you through the presentation. I won't go by word for word, but give a broad structure. I'll discuss first the general rules of drafting written submissions. And then I'll go to the legal frameworks and key legal issues that arise in privacy-related matters. This will involve a deep dive, at least from the Ugandan context, of what the laws say and what things to look out for. And then at the end, we shall give some practical guidelines on how to be more persuasive and write better arguments. And then we'll take questions at the end. So, of course, the first question that arises is what are written submissions? So submissions are really writings that are intended to convince another person of somebody's opinion. And they are usually supported by reasons, by authorities, by facts. So submissions differ from an opinion in one major way. Submissions are intended to persuade, to convince somebody, and at the end, they are intended to be believable. On the other hand, an opinion is just a statement. It's not intended to make you change your mind. It's just a statement. So submissions, as opposed to opinions, are intended to make you believe me. I state something and with the intention that you believe what I say. On the other hand, an opinion is just a statement of what I think. It's not intended to persuade you. So therefore, legal arguments or legal submissions are arguments intended to convince, but with a legal basis. So they use the law as a reason to convince somebody of the conclusion. So increasingly, and I think from research that originated from the United States, law schools are being criticized for not giving their graduates sufficient skills in training, and especially in good legal writing. So I hopefully this training will come a long way in trying to bridge that gap for those law students who may not have been properly equipped. So what are the general rules of good writing? Now, the rules I'm going to talk about are not specific to writing legal submissions, but they are general rules of writing professional memos generally, and they are transferable to legal writing. So obviously, the first rule is that they must be very clear. You'll know that it's you, the writer, it's your job to make the reader understand what you're saying. It's not the reader's job to try to figure out what you're saying. So you should make it very clear what you're saying, and so that you avoid confusing readers. Related to that, submissions must be precise. You don't have to use many words where one word can suffice. Go straight to the point, avoid excessive words. I mean, usually when we were younger, we thought that actually using very many words was a sign of intelligence. But as you grow older, I realize that the opposite is true. If you can use one word, don't use very many, because you will either confuse yourself or confuse the reader. The other obvious thing is that you should use proper grammar, and the presentation should be professional. I think at the end we will show you some sample submissions, and you will see what we mean by proper presentation. But some of the things that count towards professional presentation include the fonts. You should use the same font type. You don't want an introduction to be in New Times Roman, font 12, and then the border is in Calibri, font 13. The whole thing will look untidy. So you should should be consistent with your font. It's only unless you want to emphasize something. For instance, a quote. That's when you can use a different font. For instance, in the example, if you want to quote from a case, you can pick the exact wording out of a case and then put it in italics, for instance, to show that it's, or bolden it, or underline it, or use it in italics to show that it's been quoted verbatim from a different source. Avoid slang of any kind. Law students are usually guilty of this. You should not use slang when you're writing in a professional setting, including legal arguments. Do not use contractions such as can't, would have. You should write them in full. Cannot, not can't, or hadn't, had not. So don't use those contractions. Write the words in full. Do not start sentences with there, and, but. Those words are words that join sentences. They don't start sentences. So you should be very careful about that. Another rule of proper legal writing is don't use one sentence paragraphs. I'm sure all of you have seen those sentences where one sentence is 10 lines long, no commas, no full stop. I mean, you try to read it, you reach halfway and you lose track of what the guy was saying. So avoid those kind of paragraphs. Keep sentences short and simple. Of course, use commas when appropriate. Know when to use s, the plural, such as cats, and s with the hypothesis that is cat is bowl. Yeah? The s, the plural, and then the hypothesis. I think that's what they call it. So those are the usual mistakes we see. Then talk about only one topic at a time. Usually the beginners break this rule. People write so many things in one paragraph. So and when you're reading it, they can confuse you because you see so many different topics in one paragraph. So aim to write about one topic at a time, and you resolve it before you move on to the next. And I'll just give an example. A topic may be, for instance, an overview of negligence. And the question may be, is A entitled to workers' compensation? Or was A wrongfully terminated for filing a workers' compensation claim? Now, the first topic is about whether A is entitled to workers' compensation. So that's one topic, you can talk about it. Now, the second one was A wrongfully entitled for filing a workers' compensation claim. So there are two things. The first one, I mean, they look related, but they cannot be discussed at the same time. So you'll first have to discuss entitlement to workers' compensation. Then you discuss in the second paragraph, preferably, whether it was wrong to terminate that person because they filed for workers' compensation. They may seem related. They may be about workers' compensation. It could be the common theme, but they're actually different things, and should endeavor to address them differently. So we see many beginners putting so many things together in the same paragraphs, and they keep oscillating between different topics. That's not proper, it's not tidy, and it's bound to confuse the reader. The last thing I can talk about is what we call transition bombs. You should avoid transition bombs, which are really abrupt changes in topics. You could be talking about negligence, then the next line, somebody is talking about contract. You'll leave the reader confused and unable to follow. So when the topic changes, you should let the reader know that now we're onto something different. We can give an example. So you can say, after completing one topic, for instance, negligence, then you can say, for instance, the next topic to be discussed is, say, contract, or you can say, this leads me to the issue of contract, or moving on to the next issue, or the above situation raises also the issue of contract. So you put the reader on notice that actually we've transitioned to something else. You don't surprise them by introducing it abruptly. So that was general writing, general writing, and now we move on to structuring written submission, legal arguments. And so here we'll discuss the structure and the content of written submissions. And I'll give you an acronym to remember. It's called FIRAC. I don't know if you can see my screen, it's in bold. FIRAC, that in case you ever forget, at least you won't forget the name FIRAC. So FIRAC stands for facts, You summarize the facts, you summarize the issues, then rules and laws, then you give an analysis, and then you conclude. So that's how written argument should be structured. FIRAC, facts, issues, laws or rules applicable, then the analysis, which is the exact argument, then the conclusion. And we're going to take you through each of them one by one. And we'll begin with the facts. So facts are unemotional. Well, as the name suggests, they are facts. There's no debate about a fact. It's unemotional, it's non-judgmental, they are objective observations of reality. They are real. And I'll give an example. The boiling point of water is 100% degrees Celsius. That's a fact. You shouldn't be able to debate about it. So usually facts are founded in evidence of science. The example I've given is scientific, that water boils at 100 degrees Celsius. The other fact could be that it is raining. I mean, that's a fact. You can see with your naked eyes. Somebody can dispute that it's not raining. So facts should be things that cannot be disputed. In law, when people are arguing cases, usually some facts are easier to agree upon. I mean, if I'm in a dispute against, well, what example can I give? Yes, so if it's a marriage, for instance, a divorce petition, some facts won't be contested, that there was a marriage, for instance, and people have a marriage certificate. So sometimes certain facts are agreeable, although this is very rare. So when the facts are agreeable, then that makes everybody's work easy. But most times the parties do not agree on what the facts are. And if there is a disagreement on the facts, then that becomes an issue. And you'll see from the next part of the structure. So from the facts, you can know which one is agreed upon and which one is disagreed upon. The ones that are disagreed upon then become issues to be determined by the court, or in other jurisdictions that use juries, to be determined by the juries. So it's up to the court then to determine that, okay, is this a fact or it doesn't? So we see many students confusing facts with something that merely exists. Because something exists, doesn't make it a fact. And I'll just give an example. A law is not a fact. I mean, there could be a law, the Data Protection Act. It is a law, it is not a fact. So laws and facts are different things. On the other hand, also opinions are not facts. So, and I'll just give an example. So a plate has one slice of pizza on it, is a fact. I mean, everyone can see that there's a slice of pizza and it's one. But you saying, I like pizza a lot, is not a fact. It may be true, it may exist that you like pizza a lot, but it's not a fact. It's just an opinion. So I have another example here from which you can tell between a fact and an opinion. So the plate has one slice of really good pizza on it. Now, this is a combination of a fact and an opinion. The plate has one slice on it. That's a fact. The pizza is really good. That's an opinion. So you should always, when you're summarizing the facts, you should learn to distinguish between what are facts and what you think are facts, but actually are your opinions. So as I mentioned, it is important to know what is factual and what is not, so that you'll then be able to formulate the issues. So the issues arise out of questions that need to be resolved or things on which the parties disagree upon. Now, the issues can fall into two categories. And I can give an example. For instance, if the dispute is about a contract, and one party says there was no contract, and another says there was a valid contract, so then that becomes an issue. It is an issue the court would need to resolve. Was there a contract? So there can be two kinds of issues. The first are legal issues. These ones require judgments, legal value judgments. For instance, did the defender violate any law? Was there a breach of contract? Who is legally responsible? So those are legal issues, and they arise usually from knowing the applicable law. For instance, if the law is the law of contract, then you need to know, was there a breach of contract? Was there valid consent to the contract? So those are legal issues on one hand. On the other hand, are factual issues, and they really arise when parties disagree about what happened, about the facts. The example I can give again is one party says, I stopped at the stop sign, and the other party says, probably the plaintiff who has knocked would say, you did not stop at the stop sign when it was red. So you can see that both statements cannot be true at the same time. It can't be that you stopped and didn't stop. So one of the two is correct. So it becomes an issue which the court needs to resolve. And usually factual issues require evidence. So somebody would need to bring evidence to show that this gentleman didn't stop at the stop sign, or they stopped at the stop sign. On the other hand, legal issues are a combination of factual issues and an analysis of the law. So you look at the evidence and what the law says, and then you resolve and say, yes, there was a breach of contract, or this person is liable. So it's a combination of two things. So going back to the structure, you start with the facts, then you raise the issues, then you state the law applicable, which are the rules. The laws are really standards of behavior by which conduct is judged. For instance, if it's a privacy-related issue, you'll cite the Data Protection and Privacy Act or the Constitution of Uganda. And I would refer you to Section 14 of the Judicature Act, which has a hierarchy of laws under which disputes in Uganda are to be resolved. Of course, the first one is the Constitution, where applicable, written statutes and regulations, then case law or common law, any established current custom or usage, and then doctrines of justice and good conscience. So usually that's the applicable. You state it, the law you're going to rely on when you're making arguments. Now, this is the easy part. What I've finished is the easy part. The most difficult part and most important actually is what we call the analysis, or making the legal arguments. It's the most important and the most difficult. It contains an analysis of the reasons, of the facts, and then a value judgment for you to apply yourself and say, from considering the facts and the law, this is the position. So it is an analysis. It must contain elements of the law and facts supporting each element of the statement. So I'll just give an example. If the issue is about negligence, so there are two things to prove before finding somebody liable for negligence. So if that person has acted unreasonably and has caused injury. So the two elements is acting unreasonably, and the second one is the unreasonable act causing injury. So in order to win an argument supporting the conclusion that A was negligent, both of these elements must be articulated. They must have facts supporting them. And so therefore, for you to win an argument that A was negligent, you have to point out, first of all, the facts showing that the conduct was unreasonable. For instance, were they driving fast? Or they didn't respect the stop sign. So you have to bring all those facts, then rely on the law to show that that conduct is typically unreasonable, usually because the reasonable conduct is to stop at a red sign. When you don't stop, then you're acting unreasonably. Then you have to show that by that conduct, you knocked somebody and caused them injury. So it's a combination of so many things. And if one element is not proven, of course, or is not supported by the facts, then the entire argument collapses. Because yes, if I was unreasonable, but then I didn't knock somebody or didn't cause any injury, then you can't find me negligent. So And we usually see the mistake the students make. Usually students make this mistake is for them, they, instead of providing an analysis, they just state what the law says. The section 14 of the Data Protection Act says this. Then they also state the facts. Data was stolen. Then they leave it there and move on. So this is not acceptable. You should apply yourself and say, okay, what the section says this, data was stolen, then what does that mean? You give an analysis. You apply the law to the facts. You shouldn't just repeat the law and facts and leave it to the judges to figure out what that means. So after making that analysis, then you make a conclusion. You say, from all of this, it was negligent, they should pay damages. So you conclude and make the prayer you want from the judges or from the court. So that's the last part. FIRAC, please don't forget the acronym FIRAC. Facts, issues, rules, stroke laws, analysis, and then conclusion. So I'll move to the next part of the presentation, which is the deep dive into privacy, the legal frameworks and key legal issues that arise in privacy-related cases. I know some of the participants are not from Uganda, but I'm going to really focus on the Ugandan legal framework. But a lot of it is transferable, as I said. So probably those from other countries can also refer to their applicable laws and compare and cross-reference. So in Uganda, the first legal framework is the Constitution. So the Constitution provides the general right to privacy under Article 27, and it provides for the privacy of a person, a home, or their other property. So of course, the Constitution is couched in general terms, but it talks about things like you can't unlawfully search a person or their home or their property. You can't unlawfully enter premises of a person because that will be breaching their privacy. And you can't interfere with the privacy of a person's home, correspondence, communication, or other property. Now, these a lot of the Constitution really focuses on the home, the person, and the property. But as you can see, C also touches upon correspondence and communication. Yeah, but again, as you know, the Constitution usually provides a general framework and which other laws stand. So in order to give effect to the Constitution, the Data Protection and Privacy Act 2019 was passed. Note, however, that this act primarily focuses on personal data or information. Just to contrast this, the Constitution gives a general framework, but really touches on things like unlawful search of the person, home, and property. But now this one focuses primarily on personal information or personal data. So, if the issue of privacy is really about personal data, then the starting place to look should be the Data Protection and Privacy Act. If it's a privacy in the context of you entered my home and searched me unlawfully, then the starting place is the Constitution. So the Data Protection Act regulates basically the collection, how data should be collected, and how personal data should be processed. Now, processed means how it should be used, stored, altered, so it's a catch-all phrase that means using data in different ways. They have the Data Protection and Privacy Regulations 2021. These ones implement the Data Protection Act. They don't say anything different, but they just give it meat and substantiate the Data Protection Act. So what are the key legal issues that arise? So we'll look at these in two contexts. In the context I've already hinted on, the first being the privacy of a person and their home and property under the Constitution. So it is prohibited to interfere with the general right to privacy of a person or their home. However, you should note that, like most constitutional rights, some limitations are allowed to safeguard the interests of the public, also safeguard fundamental rights and freedoms of others. That's under Article 43 of the Constitution, and privacy is not one of those non-derogable rights. So in certain instances, it may be proper to interfere with somebody's home or their property or their person in allowable situations, as long as this intrusion into privacy does not exceed what is acceptable and justifiable in a free and democratic society. I mean, there are many cases that explain what this limitation means. I mean, Onyango Bo and others is a common case. You can go and look at it versus Attorney General. So they explain what is acceptable and justifiable in a free and democratic society means. So pursuant to this Article 43, there are various laws that have been enacted that allow an intrusion into somebody's private home or property. One of them is the Tax Procedure Code Act. Section 41 allows a commissioner for tax, that's the Uganda Revenue Authority, to access records, premises, information for purposes of administering a tax law. So if URA is looking for instance, somebody is evading tax and they have reasonable belief that they are hiding documents in their house under their bed, URA will rely on this section to come and enter your premises and search for this information. We urged a petition, as one of the lawyers, we urged a petition. It was the Uganda Bankers Association versus the Attorney General and the Uganda Revenue Authority. We tried to strike down this law for being unconstitutional. We thought that this power was too wide because it didn't have, it doesn't provide for a mechanism of the URA to get a warrant before they can come and search, but the court didn't disagree with us. They said that we were challenging some notices URA had issued that people should give it bank account information. So the court said that that's something they would decide in a case where it is relevant. They didn't think it was relevant to the facts of the case, but it's still an open question. We think that this power is too wide. It can't just give you somebody unrestrained powers to just enter somebody's house without a warrant or a warrant of court or something. But it is still the law. It wasn't struck down, so you should not take note of it. The second one is the Computer Misuse Act 2011, which allows seizing computers and searching premises upon reasonable belief that an offense is to be committed. Here, the magistrate is required to issue a search warrant for somebody to go and seize computers. Computers include phones and all other electronic gadgets, so they can come and take out your phone and search it if they have a search warrant. The other one is also the Magistrate Courts Act. It allows the magistrate to issue search warrants for premises if they believe that there is evidence in a certain premise or place that may be relevant for a criminal case. Yeah, so these are the lawful intrusion into the right to privacy. So when an issue arises, so the questions to consider was whether, for instance, the search into a person's home was lawful. Was the search into a person's property lawful? Did such a search require a search warrant? Was the search warrant obtained? And I refer you to a case here. It's a criminal court of appeal, criminal appeal number 223 of 2021, Gaston Uganda, another versus Uganda. Somebody's computers was accessed without a search order, and evidence was used to convict him. The court set aside the conviction on ground that the evidence was obtained unlawfully and could not be relied on, and as it was in violation of Article 27 of the Constitution. So when you see facts that point towards a search or entry into somebody's house or premises or office, The first question you should ask is, are they mandated to search? Do they have power to enter? Then if they do they need a warrant? If they didn't, then that would make the search unlawful. So that's the thing to consider from the constitutional perspective. The other perspective is in relation to personal data under the Data Protection Act. The basic idea that drives the Data Protection Act is that every person has autonomy over their personal data. I myself as an individual have a right to choose what to do with my data, or to choose not to give it away. So that personal autonomy over individual data is part of the right to human dignity. So obviously the first question that arises is what is personal data? And personal data in wide terms means anything that is capable of identifying a person. It could be your name, it could be your phone number, it could be your photo. You should note that usually it may not, for instance, a phone number itself cannot identify. I mean, if I wrote a number 0772 544 544, that by itself may not be able to identify a person. But if it's used in combination with other data, then it could identify a person. For instance, some people have Truecaller on their phones. If I enter that number into a phone and call it, it will bring their person's name. So the fact that if used with other data, it is capable of identifying a person, then that becomes personal data. So Alan previously talked about biometrics. Biometrics are also capable of identifying a person because I think everybody has unique biometrics. So everything by which somebody can be identified is personal data. In other jurisdictions, they use it, they call it personally identifiable information. But it makes no difference. It's really a word of it's really English. It's a difference in English, but they all mean the same thing. So since we have a right autonomy of how to determine what our data should be used for and how it should be used, the first issue that arises is consent. So generally, personal data should not be collected without the consent of the data subject. Section 7 of the DPPA confirms that. So for instance, if the facts show that my name was, or my ID was taken, the first question should be whether I accepted for somebody to get my records on my ID, my date of birth, my name, my village of birth. So that should be the first trigger. And of course, consent is a defined term. It means, again, in basic terms, to paraphrase, a positive affirmation of somebody's willingness or agreement to the collection of their data. It should be something, a positive affirmation. Somebody should have, by a positive act, shown their indication that they have accepted somebody to use their data. So again, one of the questions that usually arises is considering whether there was valid consent. So if you put me on gunpoint and you say right here that you've consented, that wouldn't be valid consent because it's not a free indication of agreement to collect data. So consent is vital, and whether it is valid consent is also usually a question that arises. Note, however, that there are exceptions to this. There are instances where data may be collected without consent, and in the privacy angles, we call this lawful basis. I can say that I had a lawful basis to collect your data without your consent. And usually the lawful bases include, they are listed in the Act, but I can summarize them here briefly. Where the collection is required by law, I don't need your consent. For instance, the Anti-Money Laundering Act mandates financial institutions, when they are opening bank accounts, to collect a certain information about a person, their name, date of birth, where they live. So if I ask you for that information, if you want to open the account, you will have to give it to me because the law requires me to get it. You can't refuse. So where collection is required by law, I don't need your consent. Where it's necessary for performance of a public duty by a public body, I don't need your consent. For instance, if you go to Ministry of Internal Affairs to get a passport and they ask you for your date of birth, you can't refuse to give it. Others, they won't give you a passport because they're performing a public duty. Necessary for national security. If they are checking maybe at the airport and they ask you for your identification, you can't refuse for purposes of national security. Where there is an investigation of crime or prevention of fraud and crime, still they don't need your consent. They can still come and ask you for your identification details if a crime is being investigated. In the contractual setting, or if you're party to a contract, and I need to perform that contract to which you're a party, I wouldn't need your consent to use your personal information. So just to recap, so you'll need to analyze whether consent was gotten, whether it was valid consent, or whether any of the exceptions consent apply in a situation. The next issue is really about personal data of children. Whenever you see they mention somebody who is a minor, who's below 18 years of age, the first question you should ask yourself was their personal data collected lawfully? And the answer to that would be whether the consent of their parent or guardian was obtained. So to contrast with the adults, the children don't give consent. It's their parents or guardians that give the consent. So that's what you should look for whenever you see a personal data involving children. The other aspect is that collection of personal data should be direct from the data subject. If you need my personal details, my name, my date of birth, my photograph, should come to me and ask them from me. You shouldn't go to a third party and get them from the third party. So the first point of call should be myself, the personal data, the data subject themselves. Of course, there are always exceptions, even here. If the personal data is already in a public record, you can get it from a public record. For instance, the Register of Marriages, I can go and look at the register and find, or at NERA, for instance, I think they have a record of all persons. You can go and get that information because if it's already in the public record. If the data subject has deliberately made the data public, for instance, if I go on Facebook and post my date of birth, I've deliberately made it public. So if somebody picks it from there, I can't accuse them of not getting it from me. The other way, exception is if I consent, allow you to go. For instance, if I apply for a job and allow you to go and do background checks on me from my former employers, I've consented to you to go and get that personal information from a third source. Sometimes it's very hard to get consent. But if, for instance, if I can't find the data subject, but I need their personal information, and they will suffer no prejudice if I get it, then it's allowed for me to get it from a third source. And lastly, when we are investigating crime or national security or enforcement of the law, we can it is allowed to get personal data from a source different from the data subject. The next important aspect of privacy is what we call fair processing information. Fair processing information is information given to the data subject before collecting their personal data. For instance, if I go to the bank and they ask me for my name and my ID, before I give it to them, they have to explain to me why they are collecting, the purpose of the information, what information they need. For instance, it could be a name, it could be date of birth, it could be biometrics, thumbprint, and things like that. They have to explain to me the name and the address of the person collecting. They have to explain to me my rights. For instance, if this information is outdated, you have a right to come and update it. They have to explain to me the period for which they will keep it. They have to explain to me who will receive this information. Now, if you don't give me this information, this what we call fair processing information, and I just give consent, then that consent would be invalid. You're supposed, before I consent, you should first explain to me the things. I want your name, date of birth. I want to use it for this and this. I'll keep it for such a period. I'll share your data with advertising agencies, things like that. If you don't give me that, then I can make an informed decision whether I should give it to you or not. If I go ahead and give it to you without that consent would be an invalid consent. Again, there are exceptions. There are situations where somebody doesn't need to explain to me why they need my data or the purpose or the nature or the recipients. And the exceptions really are focused on enforcing the law, national security, where it's a legal requirement to collect, enforcement of the law, or conducting proceedings before a court. I mean, if you are in the trial and I take your records and to give evidence against you, you can't say, but you didn't explain to me why you needed this. I emphasize this is a very critical point. And again, just to put you on alert, if you see that somebody gave consent, you will need to ask whether, as part of the investigation, whether it was valid consent. You need to ask whether they had been given this information prior to them issuing their consent. So it's something that routinely arises. The next is data security. There's an obligation to keep information confidential. So anybody who has somebody's personal information should keep it confidential and safe. So they have a duty to undertake what we call organizational measures to keep data secure. For instance, if it's electronic information, the usual things are passwords for computers. They should have safe storage mechanisms. So these they are organizational measures which are really things about management and technical data, things like encryption or firewalls. Now, my connection is not stable. So sorry, my connection was a bit unstable. So note one thing here, that there's no one set of standard by which data security is assessed, but it is a standard accepted in a certain industry. For instance, if the bankers have acceptable minimum standards of data security, information security. So everybody in their industry should embrace those minimum standards. So that's the test, though. It's an objective test. There's no one standard that fits all. So different industries embrace their best practices in their different industries. So again, the question that arises is whether the organizations undertook sufficient measures to keep the data secure. If I undertake sufficient measures and then the data is stolen or is hacked or interfered with, then I wouldn't be blamed if I can show that, well, they may have hacked into the computers, but I took the necessary precautions which are accepted in the industry. But if you don't, then you would have breached the obligations under the Data Protection Act, and which leads me to the next thing. So if there is a data breach, then you're required to notify the regulator, who is the Personal Data Protection Office. So if you read a story and you see that information was hacked, people's data was stolen, the first thing that comes to you is, first of all, whether there were sufficient measures to safeguard the data. And then secondly, if there was a data breach, did the data collector or data processor make the relevant notifications of the data breach to the Data Protection Agency, who is the Personal Data Protection Office. So those are the things you look out for data security. Another important issue is data subject rights. Data subject, as again, it derives from the autonomy over personal data. So data subjects have a right to access personal information. So I'm entitled to go to my bank and say, look, I gave you a record of my national ID. Can I have a copy of it, or can I take it back? So you have a right to access personal information. You have a right to prevent processing of personal data. If I go to for instance, I'm registering, what example can I give? Oh, for example, I'm registering to enter a competition, and I give my phone number, date of birth. If I lose interest, if I don't want to participate anymore, I have a right to go and tell the organizers that, look, don't use my information anymore. Don't send me messages. I don't want to be part of this. You have that right. You have a right to prevent processing for direct marketing. I'm sure each of you has received unsolicited messages from people sending you messages about eligibility to apply for a loan, or random messages. So that's direct marketing. They used your information to do marketing. You have a right to ask them to stop to do that. Then you also have a right to ask for rectification, erasure, or deletion. So if your personal data becomes outdated, for instance, if you say, I live in Tinder, and then you move places, then that data becomes outdated. So you have a right to go to the bank and tell them, look, delete this part of the data. I don't live at this place anymore. Or so you either rectify it or delete it or erase it. So the issue that arises out of data subject rights is whether the data subject made the request and whether the data controller complied with it. And if they did not, did they have legitimate grounds for doing so? The Act has timelines in which the data controller should react. For instance, if somebody makes a request, there are timelines, 7 days, 14 days, 21 days, in which the data controller is supposed to respond and say, look, you've asked me to delete this information. I've deleted, or I can't delete it for this and this and this reason. So the timelines are also crucial. That's one of the things you should look into. These timelines are in the regulation. So you look at the data subject rights in the Act, and then go to the regulations for the timelines, and then consider if a request is made, whether there are legitimate grounds for not complying. So those are some of the things you should look out for data subject rights. And then lastly, on this part of the presentation, there are remedies for violation of rights. If somebody believes that their personal data rights have been violated, they have certain remedies. The first is complain to the, where you can, first of all, you can complain to the data controller themselves, maybe to rectify it, or you can complain directly to the Personal Data Protection Office. In some situations, if you think you've suffered damage, you can file a suit in court and ask for damages or compensation. There are the remedies. Some of the remedies the Data Protection Office can give is they can direct remedial action. For instance, if somebody refuses to delete somebody's data, the Data Protection Office can order them to delete the data, or even fine them. The remedies are listed out in the Act towards the end. So those are some of the things you will have to look at. And this, in the whole context of written submissions, for instance, if you make an analysis and realize that there was a breach of somebody's data protection rights or privacy rights, then the next phase should be, what are the available remedies? And you'll discuss things like that. Are they entitled to damages? Are they entitled to compensation? Are they entitled to remedial action? Can I make a complaint to the Personal Data Protection Office? So those are the things you'll need to look out. My colleague Judith, I think, will take you through the next part of the presentation, which is about crafting persuasive legal arguments. So after you, and this is really a sum up of some of the things to make your argument sweet and persuasive and believable and winning. So over to you, Judith. Thank you.
Thank you, Brian, for that presentation. I think it was really, really insightful in terms of mostly the principles that you need to be aware of when you are actually drafting your submissions. So my presentation is going to be brief. It's really to drive, Brian's presentation home and bring everything into place, just for you to understand exactly how you should be able to structure your submissions. Crafting persuasive arguments really lies within simply your writing style. You need to write and rewrite and edit your submissions. Think about every argument and how it can be countered. Firstly, you have to buttress the facts with the law. You are writing arguments that are going to be adjudicated before a panel. You need to buttress your facts with the law, and that means you need to do extensive research on your arguments and on the issues raised. You need to do extensive research on the sources of the law, as Brian, earlier on presented them. Which laws are convincing, which ones are precedents, which are persuasive, which are stronger than others, and use those to buttress your facts and your arguments. Then evidential support to build your arguments. Evidence is based within the facts. You need that to buttress your arguments. You have to communicate with precision. This is the very point that Brian started with. When you communicate clearly, you drive your point home. There's a saying in writing that what reads easy, wrote hard. Basically, something that is so easy to understand is basically something that people have, tried and edited and re-edited and financed for a long time. So you need to finance your arguments. And when you come out with a clear and concise and brief draft, you will know that you have done all the work needed to present those arguments. Then you have to rely on reputable sources. This is it goes without saying. You need to know the sources of the law that you are relying upon. Expert opinions. There are dozens of opinions and judgments on privacy issues that are raised within the Moot example that Alan has given us. Always know how to balance the rights. The issue the issues that you're going to be mooting on are issues of the very contemporary elections versus privacy rights. How Alan tried to stress the issue of really the privacy right versus lawfulness and transparency and fairness within these processes. There are a lot of cases and case law that have adjudicated upon these positions. Look at the arguments that were made by those lawyers within that and try to bring them home to your case and let them build your argument while being precise and driving your point home. So that is while you're preparing your submissions in general. Then one of the crux of the matters that you're going to be handling within your submissions is that you're writing this to persuade the panel. Okay, persuading means you also have to counter opposing arguments from opposing counsel and from the other party. So these are the few key points that I'm going to discuss that will help you to be able to counter and anticipate these objections. One, you have to address them. This is a problem that very many law students face and a problem that many bring on into their career. They ignore the argument and they do not counter it. Ignoring means maybe they concede to it or they do not address it. When you do not address it, that means you leave it within the mind of the panel. When they are adjudicating, they are also alive to it and it weakens your earlier on submissions. You have to be able to address every single counter argument. And that means, for example, if you're the party that's drafting the petition, your arguments have to anticipate and counter every single argument. And you can only do that if you have correctly understood your facts and you're able to resolve all the issues. That way you can counter any anticipated argument. Preempt objections and offer rebuttals, meaning when you preempt an objection within your submission, you are supposed to understand what argument your opposing counsel is making and be able to craft an answer within your submissions. That means you have to be alive to the entire case, alive to all the different positions and all the legal principles in play. Is there any evidence that can weaken your position? There is evidence because that's why the issue is contentious. That means you have to list out your evidence that is in support of your case and evidence that is there to weaken your case. There are pros and cons, and you have to be able to play out the two and see how you can put all of those within your submissions. Can you concede the point to the opposition but challenge its relevance or its vitality? This is a trick, or really what we would say is a skill of a persuasive lawyer, especially in a privacy moot like this. You're able to acknowledge, for example, that there was an infringement of privacy or there was a breach of data. That is fine, but is it relevant to the overriding interests of your client? And be able to balance that out and convince the panel that your argument holds stronger ground, and that means your client, or the party that you're representing, has a better case than the other. That is the trick about conceding to the point, but also being able to challenge the relevance and vitality, remembering that it's an adversarial process. That means being able to convince and put out a strong argument will drive your point home. Can you explain why you're offering a new perspective, or you're bringing out a new legal principle, or you are offering a different legal analysis from what the other party is offering? That means you also have to be very convincing, and you can only do that through thorough research and being very clear within your arguments. You have to explain how your position responds to contradictory evidence. If there is different evidence, be able to relate it to your argument, relate it to your legal principle, and explain within your submissions why that party is the party that has an overriding interest, or is the party that should be argued in favor for. Then you also have to suggest a different interpretation of the evidence. As the lawyer or the counsel, it is your job to be able to explain and adjudicate the case. And that means that you may have to present a different understanding, because it's all about perspective before the panel. Put forward a different interpretation of the evidence, back it up by the facts and the laws, as we have explained within Brian's presentation, and you'll be able to have persuasive argument within your submission, enough to convince the panel. So those are just a few of the tricks to bring everything into play, as was discussed earlier by my colleague. But overall, it's all about preparation, being able to finesse your submissions, think about the facts and the law from all angles, dot every I and every T, anticipate every argument, and be able to subsume that, include that within your arguments and submissions. The difference between written submissions and oral submissions is, with written submissions, you're not going to be there when they're considering these arguments. So everything has to be on paper. Every thought of yours, every argument has to be articulated and clear on paper. It's different from oral submissions, where you may have a moment of clarity. You may have a moment to be able to bring the point home. Here, everything has to be on the paper. You do not have another chance. So make sure that all your arguments are thorough. Make sure you anticipate every objection, and make sure you are persuasive. You can only do that with thorough research and thorough preparation. Yeah, that's really it from our end.
Thank you so much, Brian and Judith, for that
thank
submission.
you, and over to you, Barbara.
Thank you so much, Brian and Judith, for the presentation. That was some piece of knowledge, and it was so insightful. This does not only equip the mooters, but it also helps us to understand how we can navigate the day-to-day data protection issues. I managed to get 2 questions from the mooters or the participants, and I will direct them to facilitators to answer. The first question is from one of the participants, and it reads, what strategy can you apply to win a case which is totally and not in your favor? This question, I'm directing it. I would like to direct it to Brian to answer, and also enlighten us more on that inquiry. Mr. Brian?
Thank you very
And
much. Well, it's the hardest question anyone has ever asked me. Strategy to win a case that's not in your favor. I think you have to approach it. It depends on what side you are. Are you the plaintiff, for instance, or the defendant? And I'll begin with the defendant. Now, if you're the defendant, the only realistic way you can win a case is to show, to really focus on the weaknesses in the other party's case. If on the face of it, you don't have a valid defense, a proper defense, then you just focus on the weaknesses in the other party's case. Now, in the criminal case, it's much easier because you just have to create some reasonable doubt. But in the civil arena, it's harder because finding somebody, winning a civil case really is on a balance of probabilities. It has to be more probable than not that somebody probably is right. So it's much harder, but that's the only realistic way. Is focus on the other person's weaknesses in their case and then cause reasonable doubt, or show that the doubts are really more probable, and therefore they affect the balance of probabilities. Now, if you're a plaintiff and the case is, I mean, you have no business filing a case which is not in your favor in the first place. So I would, I mean, that's something you shouldn't do because you lose and then even pay costs. So that's what I would say.